Good morning. Okay, well, sorry, that was. Sorry, we're a few minutes late. We're waiting for Judge Letica back there. That's a total lie. It was Judge Reardon and myself. So she was trying to hurry us along and get us out here reasonably on time. Okay, welcome to Detroit on behalf of my colleagues, Judges Reardon and Letica. This is panel 3 in Detroit, second day of our June case call. I'll let the lawyers know, as I always do. We've read your briefs. We've had reports from our staff on the cases. We know the facts. You don't need to belabor them. Just cut to the most decisive legal issues and let us know as concisely as you can why you think you should prevail in your appeal today. In cases involving minor children and protected persons, please just use initials, no full names, as these arguments are being digitally recorded and will be uploaded to YouTube within the next 24 hours. With that, I think I can call the first case on today's docket. That's item number 13, docket number 374922. People of the State of Michigan versus Carlos Skipper Jr.
Morning.
Morning.
May it please the court. I'm Joan Morgan. I'm here on behalf of Mr. Skipper. Having heard what Your Honor just said in terms of cutting to the chase, let me try to do that as succinctly as I can. The issue here is whether or not the prosecutor acted improperly in opening and closing statements as to the validity of the insanity defense. And I think it's fair to say that in this case, that was the issue at trial. In opening, the prosecutor started by characterizing the defense as, and I put in air quotes, the devil made me do it. He said that would be Mr. Skipper's defense, that because he had that defense, he could not use it as a, and again, I quote, free pass for murder. And finally, in opening statement, the prosecutor characterized Mr. Skipper's mental illness, which I don't think was at issue and which the jury certainly found that he had a mental illness, but he characterized it as saying that his mental illness was being used as a crutch in this case. So this is an unusual case where the defense had two expert witnesses on the issue of insanity.
Didn't he acknowledge mental illness as being a serious issue?
The prosecutor
Yes, he did.
He did.
Yeah,
and
so that's a little bit different than mocking it.
Well, I would say to Your Honor this. We can say it's a serious issue, which I think
we all know
we
it's a
all
serious
agree,
issue. Yeah.
absolutely. But I think the issue in terms of this case is that he was characterizing the defense as it applied to Mr. Skipper in a very denigrating way. So I think generally we can all say mental.
There was overwhelming evidence in the case. I don't know if you agree with that, but my view is there was overwhelming evidence against your client. And the issue was mental illness. So he had to argue that in his opening and his closing.
I agree with you that the issue here was whether or not Mr. Skipper was sane or not sane at the time of the commission of the offense. I agree with you, but I don't think that means that the prosecutor had to argue this issue in the manner in which he did.
Okay.
I think
so it's the mannerism that you're upset with.
I think it was unfair because I think that what happened was, as a result of the prosecutor's comments, Mr. Skipper's defense, which the law recognizes as a legitimate defense.
Absolutely.
Was laughed at and was and he indicated to the jury that this was more an issue of Mr. Skipper using the defense as a crutch, because I agree with you that there was absolute evidence in terms of the commission of the offense. That was not the issue here. The issue here was what Mr. Skipper's mental status was at the time of the offense.
So the prosecutor doesn't have to speak in the blandest terms in opening or closing, but the court also instructed the jury that the arguments of the parties were not evidence, correct?
That is true.
So why wasn't that curative instruction sufficient?
In my opinion, the prosecutor's comments went beyond what any curative instruction could have fixed. Because right from the get-go, the prosecutor denigrated the defense, and then in closing, when he made comments indicating a couple of things. One is that Mr. Skipper, in his opinion, was malingering, which I don't believe was supported by the record. He referred to Mr. Skipper lying about lift records when those records had been excluded because of a discovery violation. And he also indicated that he thought Dr. Zaborny, the doctor from the Center for Forensic Psychiatry, had been tricked by Mr. Skipper. So I think what the prosecutor did here was denigrating the defense and claiming that Mr. Skipper was somehow sneaky and was somehow using the defense. I mean, he said it outright, as a crutch. I think the unusual part about this case is that two doctors in this case, including the one, Dr. Zaborny from the Center for Forensic Psychiatry, thought that Mr. Skipper was not sane at the time of the commission of the offense. And Dr. Shazer, the prosecutor's expert, came in only because the prosecutor, in order to proceed, needed an opinion that indicated that he was sane. If there's any questions, I'm happy to try to answer them. But other than that, I think I have summarized my argument.
Any other questions? Okay, thank you
Thank
very
you.
much.
Thank you.
Appreciate your appearance and for your arguments today.
Thank you.
The case is submitted.
Have a good day.
All right, that takes us to item 14, docket number 367759. People of the State of Michigan versus Lance DeLorean Harden.
Good morning, Your Honors. Ariana Ball from the State Appellate Defender Office, standing in for assigned counsels on behalf of Mr. Lance Harden. For this argument, I will be focusing on the first three issues within the brief.
Mhm.
When looking at the warrant issue, essentially the police had a video from the drive-by shooting, as well as a video of Mr. Harden exiting a four-door sedan at a gas station, and concluded that was enough to get a warrant to search his entire life within his cell phone data. The warrants in this case lacked particularity. The warrants within the cell phone included the all in any data language, as well as listed 19 broad categories of places to be searched. When looking at the T-Mobile record data, as in Hollis, it was also 5 broad areas of telecommunications, and then that was it. It limited within the 3 days, but there was no geographical restrictions and there was no limit on what categories of data were going to be searched. So when looking at the nexus issue, which is different when looking at Carson, our case is similar in Carson as to the warrants and their particularity, but differs when it comes to the nexus issue as well as ineffective assistance of counsel. That nexus issue, there was no nexus to what the police were going to search within Mr. Harden's cell phone and cell phone data that connected him to a drive-by shooting. The cell phone, when looking at the affidavits in the affiance language, they use the language, criminals often use cell phones to communicate about crimes. They didn't include any particular descriptions about the drive-by shooting or any language about they were going to find something about the drive-by shooting on Mr. Harden's cell phone.
If we agree with you on the cell phone issue, are those errors prejudicial or harmless?
Those
There's
errors,
overwhelming evidence, I thought, the video placing in there, a couple of other things. Would it be a harmless error?
no, Your Honor. It is not harmless error when looking at the warrant requirement and the lack of particularity of the nexus issue. When looking at trial counsel's performance and the ineffective
Didn't they had triangulation of the cell phones and those things? Didn't they have that evidence and that they tracked him by video?
Your Honor, prior to getting the search warrants for the cell phone and the cell phone data, they had the video of the drive-by shooting as well as the video of him getting out of the car. That's it. before they actually requested for the search warrant. When looking at the rest of the evidence, this is the cumulative error that follows those invalid warrants.
So what was found on the phone that incriminated him?
Within the cell phone warrants, within the data that was pulled from it, it was the 13 Google searches of drive-by shootings within Port Huron. That was the prejudicial information that came out, as well as then when looking at what came out of those warrants to then use for Detective Khan's, the prosecutor's expert, for those pings within the cell towers. That's the only reason they got those was because of the invalid warrants. So that's also prejudicial. And then the prosecution highly relied on what they pulled from those warrants within the rest of their case. Your Honor, good faith does not apply when the warrants are effectively are facially invalid. So
Does it matter that Carson came out and basically said, what you were doing before, you can't do that anymore?
Carson did come out after this case. However, trial counsel did have Riley v. California that talked about the nexus issue and that the language of criminals often use their cell phones, and that's not a basis to connect a nexus to search then everyone's data in their entire lives, as well as the requirements that are within the constitutions and used.
It was search incident to arrest, whether you could search.
Correct. The facts within Riley v. California were the search incident to arrest. However, I would argue that the language of criminals often use their cell phones is not enough to connect a nexus to then search everyone's phones. And then looking within the Constitution, they did not have particularity within that search warrant and then failed on nexus, which then using those invalid warrants highly prejudiced Mr. Hardin. When turning to the second issue with Detective Khan's expert testimony, counsel was ineffective. Counsel failed to raise a Daubert challenge to Detective Khan's analysis of those T-Mobile records because it was junk science. Counsel knew that Detective Khan's used the cell tower data that was not supplied by T-Mobile. Detective Khan used his own data that he provided himself, which was not provided to the defense and was not admitted into evidence at trial. That is highly prejudicial. Counsel,
Characterized as lay opinion testimony?
could it be?
Yeah.
No, Your Honor. Cell phone tower data, it is well established that should be testified to by an expert. It's way beyond a lay witness's abilities to testify to cell phone tower data, and that's within our own experts' analysis in the record.
We see cell tower, paying data, however you want to describe it, in countless cases here. So what is it about this case that should cause us to say that this testimony is, for some reason, scientifically unreliable?
It was unreliable because Detective Khan specifically testified, and then the prosecution argued that the cell phone tower data of Mr. Hardin's cell phone connecting to his cell tower data put him in the exact place of the drive-by shooting at the exact time. Cell phone tower data does not tell you that. Cell phone tower data, when your cell phone pings to a tower, if it connects to a tower within your radius.
Okay, well, I mean, that was his conclusion that he stated as part of his expert testimony. He was subject to cross-examination on that, right?
He was subject to cross-examination. However, the trial counsel did not effectively cross-examine
Okay,
him.
well, that's a different argument then. I mean, that doesn't make the cell phone tower data unreliable. His conclusion based upon that data may be unreliable or incorrect, but that's why we have cross-examination. And so I think your argument probably boils down to just an ineffective assistance argument if he wasn't challenged on that conclusion. I understand what you're saying, that that data doesn't typically say he was in this spot at this time. It, might give you an idea that he was in a certain vicinity. So I understand what you're saying about that, but I think that's, as I say, more of an ineffective assistance argument than it is scientific reliability.
Detective Khan creating his own research and the own data that was not provided by the warrants they were given by T-Mobile is unreliable. However, if the court does not believe that that is unreliable, then it is ineffective assistance of counsel when trial counsel did not challenge Detective Khan's methodology, as when he testified, or when he said on the record, I am not qualified as a trial counsel to cross-examine or evaluate this T-Mobile data or the cell towers. And then he did not bring an expert to trial. He did not effectively cross-examine him, and he did not go within the methodology that's unreliable under Dauber and MRE 702. And that data that was used was highly prejudicial to Mr. Hardin. The prosecutor then essentially argues Mr. Hardin was there at the exact same time, at the exact same location of that drive-by shooting, when cell phone towers do not tell you that. And when looking at Detective Khan's own testimony within People v. Turner, he even testified in People v. Turner that cell phone tower data does not tell you that, does not tell you exactly where someone is at the exact same time within that area.
Not to pinpoint accuracy, but it tells you what vicinity the person was in.
Correct, which within that vicinity of the gas station, 1 mile was Mr. Hardin's own house, and on the other side was the drive-by shooting. He could be within that area. It's not disputed that he was at the gas station and then he went home. His cell phone tower can still ping to that same tower and then still be in that same vicinity. So when the prosecutor argued that he was there at the exact same time, that is prejudicial. When turning to the third issue, I would just briefly go within the ineffective assistance of counsel argument that counsel's performance fell below an objective reasonableness when looking at Officer Kablewski's testimony. That was improper, beyond a lay person's testimony. Officer Kablewski testified that the shooter's car and Mr. Hardin's car were the exact same. And then our expert testified that the video footage that showed Mr. Hardin's car and then the footage of the shooter's car could not conclude that they're exactly the same, as in the unique characteristic of the dent that was on Mr. Hardin's car on the fender of the right side of his car. So when looking within that, if the court adopts that the prosecution's argument that Officer Kablewski did not need to be an expert, then his testimony that their cars were the exact same and the prosecution's own statements that lay witnesses can look at videos and look at cars and tell they're the same, then went through the province of the jury's decision of that fact to determine if those cars were the same. Therefore, when looking at the cumulative error that led from those invalid warrants through the testimony of Detective Khan and then through the Officer Kablewski, there was cumulative error. This court should reverse Mr. Hardin's convictions, remand for a new trial or an evidentiary hearing or any relief it seems fit.
Any other questions for counsel? No,
Thank you.
thank you.
Well, I
Thank you.
agree. Thank you very much.
Yeah, very, very well done. You did a nice job and the case is submitted. Thank you for appearing today. Okay, that takes us to item 15. Docket number 363915, People of the State of Michigan versus Lucas James Peterson.
Good morning, Your Honors. Henry Schneider from the State Appellate Defender Office here on behalf of Mr. Lucas Peterson. And today I intend to focus my time on the other acts issue as well as the prosecutorial misconduct issues in Mr. Peterson's case. And fundamentally, these defects in Mr. Peterson's case shifted his presumption of innocence into a presumption of guilt. First, briefly to touch on the other acts evidence, I'm sure the court's aware that was litigated by trial counsel through an interlocutory appeal, which was denied and ultimately.
Quite familiar with it.
We know.
Yes.
At least two of the three of us know.
And with respect to that issue, we do adopt Justice Marilyn Kelly's position she articulated in her dissent in Watkins. That is that MCL 768.27A is regulating the judicial dispatch of litigation and steps on the toes of the judiciary.
And unfortunately, we are required to follow what the Supreme Court.
Understood. And I just want to touch a little bit more on that issue to explain how both of these issues together really tilted the playing field against Mr. Peterson. With
But
respect,
you lost on the interlocutory appeal. All right. So isn't that the law of the case?
yeah, that is, but we also raised an ineffective assistance of counsel issue with respect to MCR 104. where the trial court is required to decide preliminary questions regarding whether a witness is qualified or whether evidence is admissible. So very slightly different. But I would like the court to bear in mind that distinguished from some other cases, this was not a case where there was overwhelming evidence of Mr. Peterson's guilt. There wasn't physical evidence. There was not eyewitness testimony about any of the assaults. And it was a case involving sexual assault allegations against a minor. And so the courts need to be especially careful about admitting evidence that might give prosecutor an unfair advantage. But I would like to focus most of my time on the prosecutorial misconduct issues in this case. And trial counsel was ineffective for failing to challenge these instances of misconduct. It's well known that a prosecutor cannot express a personal belief that a witness is lying or telling the truth. And in this case, the record contains a significant number of instances of the prosecutor indicating that she thought a witness was honest, questioning why witnesses would make things up. But most alarmingly, around pages.
Motive. Why would they have a motive to lie?
Sure. I think the more alarming instances come a little bit further on pages 66 and 67 of the third trial transcript, where the prosecutor gave indications that she possessed specialized knowledge as to whether a particular witness is telling the truth or lying.
Where is that?
That would be the third trial transcript, page 66. Prosecutor said, first of all, when people make things up, it's not agreed to do this and that and this with them and not these things. You don't have the amount of detail and frankly, to some extent, inconsistency that you have when people are telling the truth. And she was,
That's describing things sort of in the abstract. That's not the prosecutor saying, I know that this complainant is telling the truth, and because I have some secret knowledge of that.
I believe that the statement that inconsistencies in the story are more indicative of truth telling than not is an improper vouching. She also went on a little bit further on the next page and said, if someone's going to lie to get someone in trouble, they're going to tell their story and they're going to tell that same story on and on and on, and it's not going to be, the remainder of that sentence is fairly explicit. I'll spare you the details on that, but yes, but those statements, I think, communicate a special knowledge that the prosecutor is claiming as to inconsistently actually being more indicative of veracity. And I think that was improper.
Yeah, I just see it differently. I think, again, it's an argument sort of in the abstract. You know, if you were lying, you would do it this way, not that way. You know, an argument that the inconsistency somehow makes the story more believable, you might say. So, but you know, I don't know if that's a good argument or not, but.
I would maintain that that's a personal belief as to a witness telling the truth or not.
Okay.
But moving on, the prosecutor also made an improper appeal to the jury's sense of civic duty and injected issues broader than Mr. Peterson's guilt or innocence into the trial. This was from page 66. This is in reference to TS and RC, who were other acts witnesses. The prosecutor said the system failed TS and RC. There's no doubt about it. It failed them. Please don't blame them for that. Jill Hyatt, too, could have reached out further. Not a minor, an adult, but could have reached out further, but please don't blame them for that. Please don't punish them for that failure. And the implication there, the strong suggestion to the jury was that failing to convict Mr. Peterson would be a further instance of the system failing these girls.
I think,
Go ahead.
I'm sorry.
No.
I think she was talking about credibility.
Well, I think the injection of the system, I think, implies civics, duty, our community, our governmental structure. And the implication was that failing to convict Mr. Peterson Well, the false premise the jury was presented with was that they had to choose between punishing Mr. Peterson and punishing these girls, not just the complaining witness, but the other ex-witnesses also. And I think that injected issues broader than the question of whether Mr. Peterson committed these offenses against the complaining witness and whether the elements were met beyond a reasonable doubt. Finally,
But again, the judge would have instructed the jury that the parties are not the evidence compared to the science case based on what was presented. So would that not cure your inference from that argument that it was a civic duty argument?
well, I would argue that the aggregate of errors
Okay,
combined,
so combined. Okay,
combined,
got it.
those outweighed, I think, any curative effect the instructions
Okay.
would have had. But finally, the prosecutor pretty consistently referred to the complaining witness and other ex-witnesses as victims in this trial. And in some cases, that's appropriate. In a homicide, for instance, somebody was certainly killed. The only question is who committed that crime. And in this case, as I noted earlier, there wasn't physical evidence. There weren't medical examinations. There weren't eyewitnesses. This was a credibility contest where the whole purpose was to determine whether or not this complaining witness was a victim. And for the jury to have that idea reinforced that a crime was certainly committed and that the only question was who committed it, I think eroded Mr. Peterson's presumption of innocence, at least to the degree that it occurred here. And finally, I would just ask the court to grant the relief requested in my brief, and I'm happy to answer any of the questions you might have.
Any additional questions?
What about issue 3?
With respect to Sora,
Yes,
I would argue that, well, I rest on my brief with respect to that issue. Mr. Peterson was 16 years old at the time of the alleged offenses, and I would argue it's a violation of our 8th Amendment to sentence him to Sora for the rest of his life.
Thank you very much. Appreciate your arguments. Case is submitted. All right, that brings us to item 16. Docket number 377017, People of the State of Michigan versus Kevin Scott Leonard.
Good morning. May it please this honorable court, Ed Warzani, for and on behalf of the appellant, Kevin Leonard. And hopefully honoring the court's advice on narrowing and focusing on the issues, I think our case is summarized in 2 respects. But ultimately, what we're seeking is additional discovery that is currently in the possession
Well,
of.
that discovery was voluntarily given, was it the sheriff's office?
Correct.
All right. She has no obligation to give that to you.
I would respectfully disagree. I believe.
Why does any citizen, other than having a grand jury subpoena or some type of subpoena, why are they required to give you anything?
Well, they initially were not. There was
So
a
they decided they're going to give it to the prosecutor and they don't want to give it to you.
And the mechanism in which they gave it to the prosecutor was by virtue of an unequivocal consent in a written format that says it can be used for all of these purposes. Now, because they gave it to the prosecutor, my contention would be quite differently. If it's in the possession of the prosecutor as a defense attorney, I
Well,
think I should.
I get you. I'm with you on the Brady materials, anything they're going to
Okay.
use at trial. You're allowed to look at that.
Okay,
Now, the whole body of that evidence, you want the entire, whatever was produced to the prosecutor's office or the sheriff's office, you want it produced to you. Is that correct?
absolutely.
All
By
right.
virtue of the forensic image of the cell phones that were taken by the sheriff's office, by virtue of this consent and waiver form by these 4
Some of that
individuals.
material might not be exculpatory. Some of it might not be relevant. Why is it that you get to make that call?
Pose this adverse question, why is it that the prosecutor gets to make this
They
call?
get to decide what they're going to use at the trial and they got to give it to you beforehand. Anything exculpatory in addition to whatever they're going to use, they have to give you anything exculpatory. They're required to do that.
I have a very direct response to you, because when I asked at the evidentiary hearing to Deputy Sharinka about when does he use discretion during the course of extracting information, when do you get to exercise discretion?
Okay.
His response, I believe it was page 84 to 86, his response was the entire time. So then I asked, Deputy, well, tell me, your discretion is exercised by virtue of your experience in law enforcement and your training through law enforcement? And he says, yes. I said, well, then have you ever worked for defense? He says, no. At what point in that training experience would he be able to decipher using
I
his?
agree with you on all that stuff.
Okay.
I agree with you, but it still doesn't obligate the person who produced this to produce it to you.
Okay, I respectfully disagree because it's now in the possession of
This
the
is a private
prosecution.
citizen.
I'm not asking that private citizen to give me something from them to me. What I'm asking is the prosecutor and law enforcement who have this in their possession to turn it over to defense so we can utilize this for potentially exculpatory evidence and at least review the material for such. Now, we do know by virtue of what we already received, these cell phones contain exculpatory evidence.
Can take it down a little bit.
Sorry, I have a bad habit of getting excited,
Yeah,
talking fast
That's okay.
and loud out of passion.
Hopefully, I'm not talking excitedly to you.
No, but I receive it well because I'm actually quite nervous. 17 years doing this, I still get nervous coming
Judge
before a panel
Cadola
of
has that
judges.
impact on people.
I'm very scary. I like the passion.
Well,
Keep
thank you.
bringing it.
You
Keep
know,
bringing
it happens in jury trials too, where I have to remind them, please.
Our volume here, we're not a court.
Right. Yeah, we're not a
in
jury.
front of a
I get
jury,
it.
yes.
And I do respectfully apologize, and I'm gonna step
That's
back from
okay.
the microphone if I could adjust the
Yeah,
microphone.
we're not impressed by.
No, it's
volume.
fine.
Oh, okay.
It's fine.
No,
My
no.
wife
No.
accuses me of not hearing very well. And
Well, that's
I'm now
probably
questioning
true.
myself.
I think that's
So-
a common malady.
Yeah, yeah.
So I think the law requires, and the analysis shouldn't begin from this private citizen giving to a defense attorney. They have no obligation. I could never articulate to you short of a subpoena or some court order obligation to provide me something in the context of a criminal case. I think the civil case, this information, no question, would have been provided to the opposing counsel. And a lot of what we got already from these phones comes directly from and virtue of the context of wanting to sue in these aspects. So they're prepared for the release of this information in the civil context. But to your point, I don't have any response, but that's not what I'm asking for. What I'm asking for is law enforcement to take this and provide it to, well, already having it,
And
give it to
I
me.
agree with you. Anything that they're going to use at trial or anything exculpatory, you're entitled to.
I thank you, because I agree with that too. And the
But I don't think it's you that gets to make that decision. Maybe we remand it back for a review by the trial court.
Yeah.
Well, I would submit to you respectfully, I don't think a judge would, in this context, given the vast amount, one, not judicially economical. Two, I think the best response would be a protective order. I don't give this to my client. I get to have, be it an expert, we usually use a retired state trooper, comes in and helps us go through this. It's a lot of information, right? So protective orders,
We were
absolutely the
talking
best.
about cell phones earlier.
Yeah, they're a hot topic, and I appreciate the opportunity in this context of interlocutory.
Yes,
appeal.
an entire lifetime of information now, right?
What would what purpose would that serve, a protective order?
Well, I think-
Protecting what or whom?
Well, I think the protective order would protect the sanctity of, and the sanctity of the information that may be on that phone. We readily
I
acknowledge
see.
by Carson, we readily acknowledge there's
So you
privacy
can't
interests.
take their cell phone data and just sort of share it with the world.
Can't give it to my client, can't post it on the internet. Protective orders are those best tools I think we have in the practice of law at the trial stage to preserve some of these interests. However, this isn't a privacy case. The waiver and consent form address the privacy concerns, and the prosecutor doesn't address it in the response, but they don't have standing to really assert any privacy interest. The state doesn't have a privacy interest in these cell phones. Those interests were addressed by virtue of the written
It's a
consent.
broad consent, but it's a consent that they gave to the prosecutor, not to the world. So why does the consent work to your client's advantage? They didn't consent to turn the data over to the defendant or to anyone and everyone, as far as I know.
Well, I think it's an unambiguous consent, and I think it's very clear that it could essentially, I think it's a broad consent, and I don't think
It
it
is.
says, it gives them the authority to do the transaction, but the use, I think, is really well defined as being very broad. It could go to the extent of being used to prosecute them. God forbid there's any CSAM or anything that appeared on the forensic image that would mandate prosecute, the law enforcement's follow-up. It goes to that extent. So I would submit to you, Your Honor, that if they're willing to say, hey, prosecute me for what's on my phone, I think they're very well versed in the ability to provide it to opposing counsel, especially in the context of how they're integrated into this case. So I think that that's the one aspect. And I think the lack of standing by the prosecutor even raise the privacy concerns shifts this to a waiver in the scope of waiver. And I think that the parole evidence rule really prohibits any external information or testimony coming in. Quickly transitioning to the stand away aspect, I never forget my first stand away motion before Judge Collette in Ingham County, where I had to learn that process and learn it the hard way. And I've really worked on understanding what stand away intends. Now we have a difference between privacy and privilege. Stand away really deals with the privilege aspect, and we're asking for essentially two series of documentation. The first one is going to be the Ellie's Place records. Now, this WG was obviously a victim of trauma by virtue of his mother's death, suicide, him actually discovering this being a young child, learning that his father wasn't his biological father, WG shifting to the care, custody, and control of his aunt, his mother's sister, and then being placed in Ellie's care. We know Ellie's Place, by virtue of the record, is a center designed around assisting young people with childhood trauma. Now, that was a 3-year process. We know this by virtue of the record. 3 years, weekly meetings, weekly sessions. And I think I got to backtrack briefly, all due respect. Stand away requires the first step to analyze what is the privilege, right? We take that privilege and go to the statutory confines of looking at the privilege. I don't think this record is sufficiently formed to articulate for this panel what specific privilege we can enumerate, we can guess, we can deduce, and make a reasonable inference, because the term therapist and psychiatrist and facility were terms used by virtue of the prelim or our motion. But we don't have a name of a therapist or a license number to really understand the scope. And I think that's where we start. And that falls on the prosecution, I think, to present when asserting a privilege of this magnitude. Now, Ellie's Place, to those records, I think the facts the court knows. I've tried to deduce them, enumerate them. They're, I think, well stated in the brief. But essentially, we have this individual in these therapeutic sessions for 3 years, from 97 to approximately 2000. Understanding the context of that service, that Ellie's Place, what it does, and we're having these weekly sessions, I think it's now also it's a parallel in time to when they say these sexual assaults were happening 20
Yeah, but do you
years
know
ago.
if there was any discussion with the therapist about the assaults?
Well, there's no way in the world for me to know, and I can't hide from the fact that I don't know. And I think that would say, oh, well, Mr. Zaney, aren't you going on this quote unquote fishing expedition because you would be guessing? And I think there's two things I could tell the court. One, the facts that I have available to argue are sufficient to warrant at least the in-camera review. Now, the circuit court just refused an in-camera review to compel these records and look. Okay, so what I believe is these facts that I've presented, given also what transpired in adulthood, the institutionalization, the ideations, at a time in which he spoke with law enforcement, with Lieutenant Spitzley, indicating that, hey, I'm not sure if my reality is true. Now, I would be the first to confess at the prelim I addressed this, and his response, well, I'm sure about these facts. Well, oftentimes we know mental health is serious, right? The court just stated that in the two cases ago, recognizing, I think we all do, mental health is a serious component, but I think it's equally compelling in a context where you have someone who doesn't understand their reality is true or not, regardless of the context. That requires a defense attorney, especially when you're dealing with an allegation, series of allegations from 28, and excuse the lawyer math, 28 years ago, I think. Maybe 29 now. I apologize.
Oh, you're a lawyer.
That's exactly why I'm a lawyer, and I encourage my children to be better. I look at that and I say, well, that's really important for me to look into, because these facts that we've enumerated in our brief, and I can hash those out if you'd like me to, all tie into the same thing. Thank you. This is.
Yeah, we trust me, we've read the briefs.
Well, and I do have that trust. I just hopefully have faith in myself that we've really provided you the sufficient information, the facts that we argue to support the contention we're entitled to these records. Quickly shifting to your response, let's talk about Ellie's Place. No, I don't have anything. The record doesn't support that there was a mandated reporter who took that information. Had it happened, we know under law there would have been a mandated reporter, turned it over, and an investigation would have ensued. Nothing supports that on our record. But in addition, I would contend, let's say nothing was said, or that there was never anything said by this individual, WG, to Ellie's Place. Well, I think that's equally compelling for defense given the context of what happened. 97 to 2000 is the time in which weekly sessions of therapy were occurring. That's the same time in which these allegations of sexual abuse were alleged to have been occurring. You were in a very therapeutic setting on a weekly basis. It's incumbent upon us to really take this information and evaluate it from the context of it not being disclosed, because a failure to disclose is equally compelling to a fact finder, and not just on a credibility issue, but on weighing the evidence.
That's a tough argument because it would almost overcome, I think it would overcome the privilege. I mean, if you say that, I mean, that seems to me you're almost arguing anyone who happens to be seeing a therapist at the time they're being victimized or allegedly victimized, we get to look at the therapy records. I think you have to have more than that.
But then let's consider accepting your Honor's version as being a concern. Let's talk about what we would actually receive. What would that in-camera review dole out to defense counsel to say, here's what you can get? Well, the number of visits, the nature of visits. And I don't think we're saying that, but accepting the concern and addressing it, the number of visits, nature of therapeutic sessions, the nature of therapeutic services, maybe receiving an expert to say, hey, is this the type of therapeutic environment you would set up for an individual dealing with trauma, for a child trauma survivor, and allowing that therapeutic environment to potentially expose these concerns? Because I think what you have different than every situation when you're talking about therapeutic records and the ability of those therapeutic records to be turned over to defense to outweigh privilege is one that it's a different context. First off, defendant has a Sixth Amendment right, and I think you got to go back 28 years. It's hard to defend a case from 28 years ago. I remember where I was, right? Kind of, right? So we have to build that defense, and I think that that's extremely important to consider what we need to do in this context, because it's the age of the case, because it's parallel in time to the actual allegations, because of what's transpired in adulthood. I would tie back to those facts and say, I believe we've articulated sufficiently in Stanaway. If I haven't, I'm really struggling with understanding really what Stanaway means and how a defense attorney can ever achieve Stanaway. And then at some point, when you use these facts in particular, very parallel to, I think, Caruso, are supporting in our theory that this was sometimes influenced by outside opinion. What we have, a dynamic of individuals, I hate to say colluding, but I'm going to say colluding to develop testimony or positions or discuss their testimony. That impacts people with mental health, especially when they're saying, hey, I'm not sure if my reality is real. Okay. And I say that all due respect in hopes to leverage that deference and show the deference to people in these situations. But equally, a guy looking at potential life in prison should have every opportunity to defend himself given the length of time. Any other questions?
Any other questions, counsel? No.
I
Thanks.
hope I've addressed everything in my
Yeah,
brief. and
you
I've
have time
asked
for
everybody.
rebuttal too,
Thank
so
you.
it's fine. All right. Thank you, counsel.
Good morning to each of you. It's a pleasure to meet you. This is my first time here.
Okay.
I'm Deborah Rousseau Martinez. I am the Chief Assistant Prosecutor for Clinton County, and I am honored to appear before you today, especially on this issue. First, I would like to start where defense counsel left off.
Do me a
appellant
quick
left off.
favor, counsel.
Sure.
I hate to, yes, lower the microphone.
I'm short, sorry.
Thank you. Beautiful.
Where defense counsel left off in regards to WG's counseling records. And the first thing, I know this court has read the briefs and the exhibits, the transcripts. There is an admission on the record by WG at the preliminary hearing that he did not disclose to that therapist at Ellie's Place. That admission is on the record for defendant to use, that contemporaneously during the time when he was receiving treatment for all the trauma he endured as a child, that he did not in fact disclose the abuse by his uncle. There has been nothing additional, as the members of this bench pointed out, to show that there would be anything material there in those records from that time. Additionally, context matters. And in defendant's brief and in some of the arguments made today, context of that line of questioning in regards to with the detective and with WG speaking of reality, dreams, he clarified for the record based on questions by defense counsel and this chief assistant prosecutor that that statement was in regards to the current affair of his marriage and his family, about his dreams, his reality, and things going on with that. he clarified on the record that that statement was not in regards to questioning the reality of what happened to him as a child by his uncle.
I think you're in a pretty good spot on the counseling records.
Okay, thank you. So I will move on then to the issue of the phone.
Right.
And I had this dream when I came in here about what I was going to do, and I know this is not a closing argument, and I love to be a closer, but I am going to say, your very
Maybe
kind
before
court
the-
officer told me not to pull out my phone, and my dream was to put my phone here and say, we are about this.
Coming before this panel may be more of a nightmare.
Right? Because I know this court addressed Carson and you're very familiar. And I think this court was extremely progressive and on point. And just as Judge Latika, you said about a whole lifetime that we're keeping on these devices, we have extended the right, and the court was very smart to do that. I never thought as a prosecutor and my prosecutor associates would say, you're going to the Court of Appeals to say Carson did something right? Yes, I am. Because this court, society across the country has adapted with how technology has changed, recognizing that people's entire lives, their intimate, private, medical records, things involving their children, financial records are all in that device. And when we looked at how Carson pointed that out and why it's important for the government and police to really narrow search warrants to only go where they're supposed to go, that's the same thing we have here. The impact and why I showed up today and drove here and your traffic was very intimidating, I'm going to tell you. And I was worried about parking, so I got here really early.
We're fixing the roads. We're fixing.
Okay.
Keep that in mind.
Is what it means for victims, witnesses, and people who are involved in criminal matters when it comes to sharing digital evidence
Well,
that they
here's
may
the
have.
thing, though. You were able to look at all that very personal information, but the defense was not. How is that fair?
Because this is what I learned from that evidentiary hearing. They don't look at the entire phone and all that evidence. And I personally, as a prosecution, did not either. The best practices, as they testified before Judge Barkman, to make sure we're getting what we need is to make a complete copy of the phone. Because they have the copy doesn't mean they look at it all. In fact, the detective was very specific that there's certain tools they use to parse out the information that is relevant and only go into those nooks and crannies and corners where the evidence that's relevant to the case is. And that is what he did. We, in good faith, and I think our brief showed that, have complied tenfold with the discovery rules, with constitutional requirements. And to say that we should now, because the detective, and which was clearly explained to the people who turned over their phone, that this was a limited search and they gave consent for that search, that now, even though we didn't look in those corners, that the defendant gets to look in those corners, that's the wrong message to be telling private citizens in our country about reporting crime and providing evidence to law enforcement. That an officer can tell you, we're only looking for this, we're not going to look in your entire phone, and that's what they did. Just like a house, if we had limited consent to go inside the door of a house and only go to one area and take one thing that's important to the case and relevant and material, it's the same thing here. We went in the door, we didn't look in every room. We looked for the specific things that we had consent to do.
So who drafted the consent?
The consent is a form, I'm embarrassed to tell you, by the sheriff's office that was updated in 2004.
Okay.
Oh.
So after this hearing, we did have a very realistic discussion about maybe we should look at updating your consent forms, because although the discussion was had prior to about what they'd specifically be looking for, and there is a caveat in that consent form that says they may take off what they may desire, and the desire was communicated to them that it was these messages that esteemed defense counsel brought up at the preliminary examination that were sought to be obtained, that is the door the victims here were saying, yes, police, you can go and take those messages and show them. And in good faith, we did that, because really, what is a trial about? What is this process about? It's about getting as close to truth as we darn well can. But when someone gives limited consent and the police have honored that limited consent and only looked where they're supposed to look, it feels inherently wrong to victims and private citizens to say, Now, defense counsel, you
Are
can look everywhere
Are
we
you saying
didn't.
that you've already turned over some cell phone evidence to to the defendant?
The limited material that we pulled with our search and that is cited in defendant's brief, he has actually already received
The text
information that
messages.
is helpful. Yes.
Communication.
And you're not going to use anything else at trial and
No.
there's nothing else?
I have not looked at it and the police department has not looked at it honoring what they told those
There's nothing
victims.
else exculpatory that you're going to
No.
turn over? Okay.
And I will say too, when we have delayed disclosures in cases, it is just as challenging for the prosecution as it is for the defense. It is one of the challenges with these kind of cases in the years that pass. And we have the burden. I understand that defendant is the one whose liberty is at stake, but we also have the burden and recognize those challenges. But to ensure that we are consistent with how we treat all private citizens, whether they're a defendant, victim, or witness, and how their cell phones are treated, how we search them, the people would ask that you affirm the ruling of the circuit court in regards to these discovery rules, because Judge Barkman did not abuse her discretion when it comes to discovery. These decisions were very soundly made, and the potential impact any other decision would have going forward for victims and witnesses says a lot. So thank you.
Any other questions before I let you go? Okay. All right. Thank you. Mr. Zanay?
Thank you, Your Honor. I would just quickly state, let's be real. A search and seizure did occur here. Every one of these phones forensically imaged, transferred.
They have the entire thing.
They have the entire
That's
thing.
clear.
We know.
have-
Okay. And I
Yeah.
think that constitutes at least a seizure, let alone a search. Now, the parameters of the search in which they contend I received, there was the first initial oral argument for the motion in the trial court. They hadn't even searched the term Kevin or Kevin Leonard. Again, they went back to what I initially talked about as this officer or detective using his discretion to conduct the services. Essentially, I'm being asked and was asked by the trial court to give them over my impressions of what I think needs to be searched. So we do have this information. And just because the prosecutor says they haven't looked, and I hold Mrs. Martinez in high regard, worked with each other for years. And I'm not saying she hasn't looked at something or does something or is not saying the truth to the court, but it doesn't matter. Intentional ignorance or willful disregard, Your Honor, how can you tell anybody what's exculpatory on there if you haven't taken the time to look? Wouldn't search history be important?
Was there any discussion about search terms? I know in civil discovery, oftentimes with digital records, parties agree on search terms. Did you discuss anything like that with the prosecutor's office?
We did. In fact, that was a Judge Barkman's kind of inquiry of us. I've asked the detective, what did you search? And trying to understand this, again, during the course of him
Did you
exercising.
suggest any search terms? to
I
be
asked,
used?
I think there was part of the first initial order was to go back and search for the term Kevin Leonard. And no,
Was done.
that was ultimately done.
Okay, yeah,
Yeah.
good.
Yeah, thank goodness, right? But no, and I don't think I should have to. And I'll tell you why. Because I may have something in my head that I want searched that I need to figure out that I should not have to share by virtue of attorney-client privilege, the dynamic between myself and my client for those terms, or alternatively, my work product, my impressions of what I need to figure out. And ultimately, this isn't a privacy case. Carson is a great case. I love it. I can utilize it. And I think everybody's really adapting well to it. But this isn't that. This is a
Privacy case for the person who produced the cell phone? Doesn't she have a privacy right?
sure, but they gave it up. And the waiver's
They
pretty
gave it
clear.
up to one party.
I would respectfully disagree. I think they gave it up to the context of both the search and the seizure in the context of an ongoing criminal case, which they knew and were
Well,
participating
that's where
in,
we disagree. They didn't give it up to the whole world.
which is why a protective order would be the ultimate conclusion that I think this court should reach, an appropriately worded protective order, limiting its scope. This doesn't go to the defendant. When they say that, that's kind of salacious, right? Goes to my client. It doesn't. It comes to myself, the
You're
attorneys in
his
my office.
agent.
Sure, and I have
mean-
I'm bound by that same protective order, right? I take those, like federal court, those are pretty scary, right? And I think in state court, just the same, because if you have a misstep, that's your license, that's your reputation, that's your own, moral compass. You feel horrible about it. So I take those things quite seriously. And the attorneys in our office, we have policies and reflective of that to make sure we're honoring the scope of that. But ultimately, that's the way you balance the perceived privacy interests, which were waived, and I contend they were waived. And I appreciate the court's position that to a certain party, but by virtue, it was for everybody, and the prosecutor has it. And the prosecutor having that, I want to be comfortable saying, hey, I've checked everything, or I haven't checked anything, but don't worry, there's nothing exculpatory on there because, we haven't checked. And I want to be fair to do that to Mrs. Martinez if I was in her role, because I would say that the cell phone, as much as we know there's private information, can be balanced with the protective order, and frankly put, is going to have more information. I mean, the nature and scope of how you run those parameters and searches on the text is extremely important to defense. And I think we should be entitled to the whole phone to look at it and then return it. Oftentimes in federal court, we're mandated at the conclusion of the case to return it. Michigan rules of professional conduct maintain things for 5 years. We balance those interests by virtue of that very strongly worded, very narrowly tailored protective order to allow us access to do our job and protect the Sixth Amendment right.
Anything else for us, Mr. Zanay?
No, I think I've done my best. If I erred in any way,
You did very
excuse
well.
me.
Yeah.
All right. Well, I
All right.
appreciate
Certainly
the time.
have.
Thank you very
Have a
much.
good one.
You both did a very nice job, Ms. Martinez. You certainly didn't display any nervousness in your first argument in the Court of Appeals, and it was well argued on both sides. Thank you. The case is submitted.
Travels on the
I'll
way
be on
home.
the road right
Travels.
behind you in a couple of hours on your travels back to, oh, you're going north? Okay. I'm going back to Lansing. Yeah. Yeah, right. Okay, thank you. The case is submitted. That brings us to item 17, docket number 371014, Kurt Griggs Swanson versus Beaumont Farmington Hills.
Good morning, Your Honors.
Good morning.
Are we okay to start, or we?
Oh, yeah.
Okay.
Of course.
Good morning, Your Honors. May it please the court, Carla Akins on behalf of the plaintiff, who's also the appellant in this case. Your Honors, I'm not here to argue whether or not the immunity applies and all of that. Even if it does, this case was dismissed too soon. The point is that summary disposition is supposed to be when you've had a full factual record per the rules, and that did not happen here. I was involved, and so the judge on the second case is not the judge from the first case. And so I'm not going to say misled, but may have believed that the record was more developed than it actually was. I was at all of the hearings on the first case where the defendant did everything they could not to get discovery to us on the case. We got nothing in the way of medical malpractice. That was a specific bar. And so, sure, we've got facts related to my client, what happened from his position. We had depositions. None of their witnesses remember anything, not even the things that are in the report. So, if this matter were to go to trial, then that's a different issue, because then they're going to have a burden themselves to actually know what happened and all those things. Nobody remembers anything. But the people who do remember are my client and his colleagues, his boss, who saw some of the goings on in the tent. But we don't have anything in the way of evidence to support the policies, the same things as they're saying were okay. We don't have any of that. None of the policies about admissions, when do you call the police, who called the police, the security, all of those things. And so all I'm asking is very narrow relief, which is that the case be remanded for us to be able to get to whether there's gross negligence. I looked around, I didn't see any cases really in the state of Michigan, but there were some cases outside of the jurisdiction related to, I think, the idea of the failure to intervene and to do anything. And that's what happened here. It wasn't just, and that it was intentional. Obviously, what happens next is important. And so what happened here is he ends up being hospitalized on a ventilator for 11 days. And they refused to test him, had a canine dog out there, dragged him on the pavement, to the point that his congresswoman writes a letter to the hospital, like, what is going on? And so all of those things, that's all we're asking, is for very narrow relief. I'm not asking you to find anything related to the statute, to immunity or anything of that nature. So unless you have any other questions for me, I will.
Any questions for counsel?
No. Okay, thank you very much.
We'll have time for rebuttal.
Okay, thank you.
You hear me okay?
Yes.
Okay. Good morning, Jackie Klein on behalf of defendants Beaumont and Dr. Kaiser. Those are the only two left in this matter. The nurses have been dismissed. All issues regarding the security guards have already been decided. That case is no longer pending at the Supreme Court, so none of those issues are relevant to this particular case. All the racial allegations are out by the federal court, which was never appealed. So we're down to only what Dr. Kaiser did on that day, which falls squarely within the Immunity Act. The allegations don't even amount to negligence, let alone gross negligence, and no further discovery would reveal anything. The medical records are clear. He went there, he had a slightly elevated temperature, which was 100.5, not 103. All his vital signs did not meet the requirements needed to obtain a test. He was treated as if he had COVID, as if he had tested positive. He just did not receive one of the rare tests because he didn't fall under the protocols in place at the time.
I think you've summed it up very nicely, Counselor.
With respect to the case, she said there were no cases where the failure to do anything did not fall within the Immunity Act. There are 4 unpublished cases. I think this act has been very well established under case law.
I wrote an opinion about it. So
Yeah.
I think we know.
Okay.
Is there anything you?
No, I was just gonna say
feel
there are
compelled?
four cases where the failure to act did not qualify, and the same where gross negligence was
Are they in the
rejected on
brief?
discovery. So,
Are they in the brief?
so
The 4 unpublished cases, did you
well,
cite them in your
the
brief?
first Griggs case is one of them. The Anderson v. Ascension, Monroe v. St. Joseph, and the Johnson v. Beaumont, which was one of mine that came out later. Again, I think this is my 4th case on this act, so hopefully final one. And then as far as rejection of gross negligence, the Harris case is in there, the Warren, which is really, should be called Franklin, and again, Johnson, and this one, so.
Okay.
Unless you have questions, I'll rest on my brief.
I think we're all set.
Thank you.
Thank you. Counsel, do you have any rebuttal?
The issue here is that it's not whether further discovery is not warranted. There's been no discovery at all into anything having to do with the medical malpractice case, intentionally so. And so that's the issue. Under Maiden, MCR 2.116H, you have to actually be able to make a factual record. If we end up, in the same position at the end under C10, understandable, but we have not had that. Everything that they just cited to you are facts that are, some those are not in dispute as to what his levels were and all of that. We're talking about medical judgment here. We submitted an affidavit. They haven't done anything with respect to the merits of the actual case. We're just asking for him to be able to have discovery finally on the medical malpractice case. And I didn't say that there's no case that's found that there was what constitutes gross negligence. I was talking about this type of factual scenario. Again, if you apply the statute, we still have gross negligence with respect to that. If we're going to say that these set of facts don't meet the standard for gross negligence, that means that we are applying the statute. I'm not saying that it didn't apply. What I'm saying is we have not been able to make a factual development to find out whether or not gross negligence was met because we were blocked from getting it. So it's just simply not true that we have any of the facts that go to that standard. And so if you can't even prove your case, I don't know where we go from there. I mean, we should not be allowed to get rid of a case because somebody said this is what these things are. I mean, we haven't had discovery at all in this case. It was dismissed right from the outset. So all we're asking is for a chance to actually be able to plead.
Prior lawsuits?
Not on medical malpractice. Not at all. The only the cases she mentioned, which was true, is that it had to do with the guards themselves in the negligence case. Now, whether I agree with that outcome, it is what it is, but those are 2 separate cases. We tried to add.
Nurses.
I'm sorry.
I thought she said the nurses.
The nurses were dismissed because we didn't have a nurse, not because the case was decided on whether nursing was an issue, if that makes sense. It was not. No, we did not have a nurse expert to go with the affidavit of merit. That's all. So again, there's been no decision on that part of it. So that's why I'm saying we're just asking to be able to actually have a factual development. If the statute says gross negligence, you should be able to actually develop facts to prove that. This is notice pleading. This is not fact pleading. And we don't even have the facts. So, I don't know how they can tell us what we need discovery into or not, but I've delineated exactly what discovery is required. And so I'm just asking that you reverse on that very narrow issue, not having to get into any opinion that you may have written with respect to the applicability of the statute. Even if that statute applies, and I'm assuming that it does. Let's say that it applies in this situation, because I think that's what it was supposed to go to, was whether or not in a very difficult time, you doing experiments on patients or using experimental medications. That's what this was supposed to be about, not we assumed you have it, so we're going to call the police dogs on you and then have you dragged out. Then nobody's going to remember anything about what happened even a year later. And that's what happened here. But again, the defendant hasn't had to come into court and do anything, and plaintiff has come forward with at least some evidence. We should at least be entitled to discovery before this case is dismissed on its merits. Thank
Okay.
you.
Thank you very much. We appreciate your appearance here today and your arguments. The case is submitted.
Thank
Okay. That brings us to item 18, docket number 375146. Estate of LaShunte Smith versus Protector Window and Door Incorporated.
Good morning, Your Honors. Brian Katinsky on behalf of the plaintiff. I know we had an attorney here before me that said this was her first argument. I'm here to say this is probably my last. I've been doing this for 40 years,
Oh
and
my
it's a
gosh.
wonderful way to sort of wind
You
down.
must have started as a lawyer when you were about 10 years old.
Well, thank you, Your Honor, but I think I look every bit of my 65 years old.
Are you going to fully retire at 60?
No, sir. It takes a while in this business, so I'm just sort of sliding out, but I'm never going to totally retire. There's still plenty for me to do, as you
You're just going to retire from us.
perhaps, yes, that's it. My name is Brian Katinsky. May it please the court. There is no dispute that the defendant in this case owed a duty to LaShunte Smith. It was both a contractual duty and a common law duty. And we have presented evidence that that duty was breached. The primary issue before the court today is causation. That is, whether there's a nexus between this malfunctioning door and my client's injury. And unfortunately, as the court knows, my client, though there was some discovery, she died before her deposition was taken. She did answer an interrogatory. The evidence is that the defendant installed the door. Now, this was a heavy security door, and I think it's important because most of us think, when we think of our storm doors, it's a screen door that slams shut or a storm door. This was a security door that was 80 pounds by the defendant's representative's estimate. It was a heavy door. It was installed on April 8th of 2022, and within about 3 to 7 days, Pearlie Smith, the homeowner, age 82, noticed that the door was slamming shut. And she told her daughter, Katrina Kiles. And we have testimony from Ms. Kiles that she called the defendant 10 times before this incident, 10 times to report the problems with the door. And despite that direct notification, defendant did not service the door until May 11th of 2022, about 3 weeks after this injury. And when they came out to service it, they learned that the door closing mechanism was not working properly, and it was replaced. Now, before this, on April 19th, LaShunte Smith, the decedent, was walking into the home. Her account of the incident is in her interrogatory. She states the storm door closed on me as I was entering the threshold to the house, causing me to lose my balance. Her brother, Andre Smith, witnessed the fall.
He did not witness the fall.
Well, he was right behind her. He was right behind her.
Yeah.
So I'm sorry.
I think it's undisputed that he didn't see it happen.
Well, he was right behind. Well, correct, Your Honor. Okay, yeah, that is
Careful.
there's a correction. And
Yeah.
he was behind her. He came upon her. He saw her foot stuck in the door. He asked her what happened, and she said the door closed on her. So you're right. He was in the area, but he did not say he didn't see the door strike her.
Okay.
So I apologize for that. EMS was called. Their records state her foot got caught between the screen door and the step of the house, causing her to fall. Now, the issue here is causation. Do I have a sufficient nexus? And we go back to the Skinner case.
Mhm.
And I have presented, I know you're looking at me sort of skeptically, and I see you're skeptical, okay? And maybe, Judge Godola, you would be on the jury and you would say, I'm not buying it. Okay? And you might not. But my point is, for these purposes, for here today, there is a sufficient evidence to present this sequence of events to a juror. And very well, there might be a reasonable juror who might say, you know what? That's an 80-pound door. It was malfunctioning. They called the defendant knew about it. They did nothing. This woman falls, her foot is caught in the door. And yes, there is that logical sequence of events. So I understand, Judge Godoy, I might not convince you. I might not convince any of you, but I believe there are logical jurors that could be convinced. And I believe my client is entitled to her day in court.
Aren't we left with further speculation considering her pre-existing condition?
Well, Your Honor, I'm not sure.
She had some pretty severe medical issues.
Sure she did. But aren't those questions of fact? In other words, she did have serious medical conditions. She ultimately died. But to say that her medical conditions caused her to fall at this precise moment. So I think
Goes
these
to
are,
damages, doesn't it?
yes, that goes to damage, but those are questions of fact. And all I'm arguing, Your Honor, is that let a jury decide this, because those do go to
I
questions.
understand what you're arguing. You
Okay.
want your day in court.
Yeah, and she's entitled to it because I believe that there's a logical sequence of events as to what happened here.
Well, I think the point is, isn't it just as likely as the theory you propound that she tripped and fell over the threshold of the door due to problems with her leg and, excuse me, but her severe alcoholism, that those two things in combination perhaps, or either of them, were just as likely the cause of the fall as the door.
I think that's a bit of speculation, Your Honor, if I may.
All we're left to do,
Well,
it seems.
no, because we know this, and this is like, again, this is not just a regular storm door that most of us have. in
Well,
our
she
homes.
had a limp and she had issues with sensation in her feet. She couldn't feel things. She walked up to the door with a limp, right?
She walked, but she is to be taken as she is, just like any of us,
That's
okay?
true.
But what we know is this door had been malfunctioning. It's an 80-pound door. It closed on her foot. We know that there were problems with this door, and it's about accountability. The defendant knew there were problems with this door. That's what the evidence shows. They didn't do anything about it. So I understand there's arguments to be made. Mr. Brower, an excellent attorney, I've known him for most of my 40 years. Dave. I believe, Yates, Mr. Yates, I'm sorry, but what I'm saying is there are arguments to be made, certainly, that her health conditions maybe contributed to it. But when you have this situation with this testimony, I believe that there is a logical sequence of events from which a reasonable juror could very well conclude that but for this malfunctioning door, which we know was malfunctioning, this incident would not have occurred. And that's what Skinner requires.
Okay. Anything else for us? I think you've hit on it's a causation case, so.
I think it's interesting, and it would be a good case maybe for law school or something. But yes, I believe there is a logical sequence of events. If you were on my jury, I might not convince any of you, but I believe
You might, you're very good.
Well, thank you. I appreciate that. And it's very nice to end my career, so to speak, with ending it, I should
Oh,
say.
you have a rebuttal.
Before this. You're right. I shouldn't rush myself.
Not so fast. Okay, thank you, counsel.
Good morning, and may it please the court, David Yates on behalf of defendant Applee Protector Window and Door, and it's an honor to be here. I'm going to be very brief. Your honors have seen the facts, read the briefs. This is a case about speculation all day long. What we do know and what the evidence has shown is that possibly the door was involved in the accident, but no evidence that it was
The proximate cause.
the proximate cause, or that it was installed improperly or malfunctioning that day. And the plaintiff had many opportunities to express that, and counsel went over some of it, her own interrogatory responses, which she doesn't say anything about slamming, closing hard, closing too fast, statement to her brother, EMS, the emergency department, her grandmother, her aunt. Never are the words slam, close too fast, or too hard on me ever mentioned. So that will never come into evidence.
I have a sort of very specific question about the facts. She had the ankle injury due to a fall that occurred 5 days earlier. And that, I think, is what caused the limp that Judge Reardon mentioned. She also had neuropathy and tingling and numbness in a foot or feet. So was it both feet? Was it, and do we know? And was the neuropathy, if it was only one foot, and the same one as the ankle injury?
Wish I would have drilled down that
Yeah.
hard on the facts, Your
Me
Honor.
too.
My recollection is it was both feet. I could be wrong. I don't
neuropathy.
want to, yes.
Yeah.
But it's a very,
Okay, well, you have rebuttal.
it's a very good point, because it is one of our issues, is that who knows why she fell, right? Maybe the door had something to do with it, but certainly we don't have any evidence that the door malfunctioning had anything to do with the fall. And it could have been expressed, as I said, in a number of ways. It's left us with just pure speculation. I mean, even if she were to have said it closed too fast, how fast? How hard? We don't have any of that evidence, and we never will. So they'll never be able to prove their case beyond pure speculation and conjecture. I think I'll just leave it at that.
Fast enough that they complained about it on multiple occasions to your client to come out and fix it. So
Allegedly, that is their argument. There's no proof, other than their testimony in this case, that any call was made prior to this accident. We only have proof of calls after the accident.
Okay, so yeah, can I follow up on
yeah,
that?
please.
So you have documentation that that was when it was made after, the complaint was made after. And I'm getting confused as to who actually called. Was, because he said it was the sister, I think, that,
Daughter.
or daughter, I'm sorry,
Daughter.
daughter that lives with the grandmother.
They actually all lived there.
They,
The plaintiff
yeah,
lived there, the
okay.
sister lived there, the brother, everyone's living in this
Did the
house.
plaintiff herself call?
I don't think so, no.
Okay,
I think it was the sister. That's what, I
Okay.
mean, our records are not super clear. There is a record of them calling after. There was a record of us going out to see what the issue was. I think the underlying, the judge in the trial case did mention this could be a subsequent remedial measure issue, and none of that evidence would ever come into court. Because we don't even know if we replace the closure or not. I mean, the closure is adjustable too. Plaintiffs, and the mother could have just adjusted it, made it a little faster, slower. There's just so many speculative arguments in this case. It should never see a trial. And
and your person said that the installer said that they make sure that it's working.
and
They leave, so who knows what happened
after.
thereafter.
And the plaintiff did indicate she was satisfied with it after it was installed and that it was working the homeowner indicated it was working properly and she was satisfied. We know
Mother,
the grandmother, right?
okay.
Which if anyone was going to argue it was closing too fast, probably would have been her. But it was working properly when we left. So as far as a negligent installation, it seems like we installed it, right? Did they adjust it? Did something happen? We'll never know.
Did somebody hit it and knock something?
Or did it even close fast that day? We'll never know because there's no testimony from anyone that it did close fast that day.
It was just a threshold issue, is what she said.
And if you look at the photographs, you'll see there's like an unusual kind of high ledge that could easily cause a trip. Maybe that was it. It's all speculative.
All right,
Any other questions?
Nope.
Okay, thank
Okay,
you.
thank you.
Any rebuttal, counsel?
I just want to focus. Gates said that his records are a bit unclear. They are unclear. The testimony and the evidence, Your Honor, is that the calls were made by the daughter who was not, by the way, living at the home, but she called several times. It's very clear in her testimony who she spoke to, what they said.
so it's Kayla,
Katrina Kiles.
Katrina.
Katrina.
Okay,
I have
Kiles.
Lashante and Duncan made several.
But it's
calls.
not plaintiff.
It's not the plaintiff. Lashante was the plaintiff.
Okay, that's,
Okay.
According to a deposition, it's Lashante and Duncan made several. calls.
yes, that's,
Okay.
I
Okay,
think that's
it-
what our record
but if you
shows,
s-
which is why I wanted to ask, because I don't think that it does show that, but that is not consistent with what I saw.
Oh, Your Honor, I do believe that I put a big excerpt from Katrina Kyle's deposition into the brief at the.
Oh, okay, so
It's right
maybe,
there.
maybe we've not identified it correct. Okay, I got
Okay.
it. All right, we'll go back and look at
The other thing, Judge Godola, you mentioned the proximate cause. As you know, this is not an immunity case. It can be there. It's Okay, so that I want to distinguish
Good
that
point.
because it's not immunity, and I don't, and I know you had a case that earlier today that might have been an immunity situation. This is not one of those. It's a proximate cause. We know, and whether this was a subsequent remedial measure, if it went to trial and they say it was working properly, then it comes in for impeachment. You replace the door closing mechanism. There are many questions of fact here. I understand that there are very good opposing arguments, but my client is entitled to her day of court in court because there are a lot of factual issues and there is a logical sequence of cause and effect. And with that, I will end my argument. I want to thank you, and it was truly a pleasure, and I really did enjoy it. I'm
Thanks,
gonna miss
Mr.
this.
Kaczynski. Congratulations on your semi-retirement.
Well,
and
it's just act two. After 40 years, it's
Right.
just an act two.
It's a long time. So
So good
I'm
luck.
looking-
Let's go, young man.
looking forward to it myself.
Thank
See,
you.
we can say that because we're the same age as you are.
You look fabulous.
Okay, thank you. The case is submitted. Okay, I think that brings us to the end of our 10 a.m. call. Do we need to take a break, judges? Should we take a break
Oh.
or?
I'm going to ask for one, if you don't mind.
Yeah, okay. We will take a 5-minute recess and come back to begin our 11 a.m. call. Thanks. Okay, good morning again. We are now back for our 11 a.m. case call. Just tell the lawyers again, remind them that we know the facts. You don't need to belabor them. Just cut right to the decisive legal issues and let us know succinctly why you should prevail in your appeal today. With that, I can call the first item on the 11 a.m. call. Item 19, docket number 374164, Christine Roddy versus Anna Carcamo.
May it please the court, Tony DePony on behalf of the appellant. I'd like to reserve 2 minutes for rebuttal, but I am confident that
Won't need it all.
I'm confident as well.
I was gonna say, if you were arguing 28 minutes.
the trial courts in Michigan have long been governed under the doctrines of adverse possession and acquiescence in order to move boundary lines. The trial court in this case made factual findings that the elements of adverse possession had been met by making material inferences which were inconsistent with what the plaintiff argued. The plaintiff argued that they had installed a fence in 2004 at the location that it was in commencement of trial. It was approximately 51 feet long. And what's unique about this fence is it has a large overhang, which makes it clearly visible from aerial photographs. And the aerial photographs didn't depict it through 2008, but did depict it in 2010. Nevertheless, the trial court made findings that a fence had been installed in 2004, taken down, and a new fence had been installed in the same location between 2008 and 2010. We believe that using such material inferences which deviate from the factual testimony that the plaintiff had given do not meet the clear and convincing standard, and we believe that's error. The second issue relates to the edge of the fence to the front of the property. Very little testimony was given about this dispute. Plaintiff was seeking to move the boundary based upon aesthetic reasons. The trial court concluded that she was moving the boundary using her equitable powers. There was no analysis of the balancing of the equities. There was no analysis of why it should be moved under either the doctrines of adverse possession or acquiescence. So we believe that the court erred there as well. I'm available for any questions.
Any questions for counsel? You will have rebuttal, well more than 2 minutes. All right.
Thank you, judges. Nice to see you, Jim Razor. on
Good to see you,
behalf
Mr. Razor.
Of the appellee, along with my colleague attorney Amanda Washburn. We are just delighted to be here to argue this very interesting real estate case to you. I've only been practicing law 37 years, so I feel like I'm like kind of in the middle of my career. I hope.
Right. Let's hope so.
Let's hope so. I get that everybody gets an appeal as of right from a trial court, but I practiced law, like I said, for a long time. I've tried cases in front of Judge McMillan, who I have the highest respect for. I think she did everything perfectly wonderfully in this case.
I'm sure you do.
I don't know if you heard Judge Godola, so do we.
Yeah, I did hear that.
Respect for Judge McMillan.
Yeah, I did hear that. She was just a wonderful trial judge. I enjoyed trying cases in front of her. I found her to be just and firm and fair. And this was a great opinion that she wrote in this particular case. And as you know, you would have to find that her opinion was clearly erroneous in this case. And it's just simply not. Clearly erroneous is if you review the entire record, you have a definite and firm conviction that a mistake was made. And I just don't see it. First of all, counsel said something about clear and convincing. These cases are civil cases based on a preponderance of evidence. The great deference, as you know, has to be given to the trial court based upon the trial court's view of evidence, the credibility of witnesses. And the trial court even mentioned that the trial court believed that some of the witnesses, one of whom was 9 years old at the time, because of their relation to the defendant, just weren't credible in this case. And the fact is that the trial court was in a better position to look at the evidence and look at credibility determinations and make findings of fact in this case. The appellant really wants to make this into a fence case and really wants to talk about the fence. But what the appellant is really missing is that there were many more indicia of both parties believing this was the property line, going back at least to 1991 when the driveway was constructed. There was consistent and exclusive acts of possession, including use of the driveway, yard sales, general maintenance, expanding the garage, all sorts of things. So it's just not a fence case. But let's assume that we buy the argument from the defendant. And the defendant's argument is essentially, don't look at Exhibit 1, which is a photo of the fence in 2004. But look at some grainy photographs from space that show that the fence might have changed in configuration based on the top of the fence. Who cares? Acquiescence is based upon what the parties consider to be the property line. Whether they consider the property line to be a fence that changed in some way, maybe, doesn't really matter. The crucial inquiry is, what did they consider the property line to be? And the thing that is shocking about this case, it makes me wonder what we're doing here, honestly, is there's no evidence from the appellant that they used this land, that they considered it to be the land, that they did garage sales on it, that they put their driveway on it, that they fought with their neighbors about it for more than the 15-year period of time.
Client testimony was planted flowers and shrubs in the disputed area, mowed the grass in the disputed area, parked cars in the disputed area for a very, very, very long time. And that area was consistent with the line of the fence that stopped at a certain point, but then unfenced running southward towards the road. So,
right.
Am I characterizing that accurately?
You're characterizing that accurately. I didn't hear the first part of what you said, but I think you said plaintiff Roddy said that she did all of these things. Yeah.
Yeah.
So
your client
concomitantly, and I love using that word, triple word score. Concomitantly, the defendant did not testify that they ever used that piece of land whatsoever. So if we have acquiescence, which is where the parties thought that the property line was, it's a slam dunk. I don't think that there's anything about this opinion, and actually I hope that you don't think that there's anything about the trial judge's opinion, which is in any way requiring you to exercise any review whatsoever. I think the trial court did a great job with their opinion. I think the trial court bent over backwards to try to be fair in finding that that there should be a diagonal coming back from the fence line to the street line, which actually gave the defendant more property than they were entitled to, based on the fact that Roddy testified that they had used that portion of the land for parking and things like that. I just, I struggled today, as I always do with my colleague Amanda Washburn, to try to construct the appellant's arguments for you. And I actually asked Ms. Washburn to make the appellant arguments, and I tried to make the appellant arguments, and obviously it's a much weaker side, and it's weak to the extent that I feel very confident in urging you to adopt the trial court's opinion, not find that it was clearly erroneous, not find that there was any error whatsoever, and to issue an opinion affirming the trial court. I would be delighted to answer any questions,
I don't think we have any.
just because I like talking to y'all and you ask great questions.
Well, I think we've heard enough.
Thank
So,
you.
Thank you, Mr. Razor. Any rebuttal, counsel?
Thank you.
Sure.
I would point out that the trial court did find that the Reichert survey, as proffered by my client, accurately depicted the boundary line. Then brother counsel has indicated the standard is preponderance of the evidence. It may be preponderance of the evidence for acquiescence, but the ruling was made under adverse possession, and that standard is clear and convincing. And judicial inferences which are inconsistent with plaintiff testimony, I believe, should not be utilized when that higher standard is the standard. And then counsel made points that the use was exclusive during that time period. You know, there was testimony on cross-examination that her use for yard maintenance and garage sales was not continuous. And then the dirt driveway that was installed was more, she acknowledged that it was narrower than the concrete driveway that she ultimately installed. And with that, I'll conclude my arguments. Thank you.
All right. Thank you very much.
Thank you very
Appreciate
much.
your arguments and your appearance here today. Appreciate it, and have a
Last
great
time you were here, you
rest of
said
the day.
your colleague, Ms. Washburn, was the brains of the operation. I thought she'd argue.
We know that.
Right.
Yeah, so that's, I thought she would be arguing tonight. I'm glad the
You know.
brains argue.
I think that would have been wonderful.
Well, I can't tell you what to do, but you called her the brains of the operation, and we agree, so.
Next time.
We all know, right? We all know. And Amanda has been such a benefit and such a blessing. And you know, with an 11-year tenure at the firm, 3 of which, right, coming up as an attorney. And it's just delightful, especially when we're talking about being of retirement age and, you know, being at it for a long time, to have such fired up and, you know, smart young lawyers coming up the ranks.
Right.
Ms. Washburn asked for a raise.
Today's the day. Did you work as a paralegal at the firm?
I started as a receptionist when I was
Oh, my
19,
gosh.
Oh, my
Oh,
goodness.
that's great. That's a great story.
Receptionist, intake coordinator, legal research clerk, and then,
Wow.
you know, associate.
Well, if you can withstand 11 years with
God,
Mr.
yeah.
Razor. you can
Anything
do
else is gonna be
anything.
a walk in the park.
Right?
All right, the case is submitted. Thank you
Thank
very
you.
much.
Take care. Have a good day, gentlemen. Take care. See you.
Okay, item 20, docket number 374-828, Grace Howard versus Bruce Smoller. Ms. Howard? Yes, you're the appellant, which means that you argue first. So the time is now yours. So if you want to step to the podium, you can present your argument.
Good morning.
Good morning. Just give us your name
My name is Grace Howard.
and you're representing yourself here today, correct?
Representing myself, sir.
Okay, go ahead and tell us why you think you should prevail in your appeal.
Okay, yes, well, I'm sure you have read everything
We have
concerning my
indeed.
complaint.
Yes.
Okay, and so if we go to the statement of facts, page 6. First page, page 6, it says, after approximately 2 years of medical confusion, the plaintiff discovered the true nature of the full mouth implant failures. Skip down. I discovered the malpractice, immediately filed my complaint after I received an affidavit of merit from a dentist. The dentist wasn't able to give me an affidavit of merit, and I believe the court rule says you have to have an affidavit of merit before you can file a medical malpractice. So I waited for the dentist to keep checking me to see what was going on with my implants, and he finally decided, what the failure was.
Mhm.
So I filed my case, you guys should know that, on September 26th. When I filed it, the rejection came back at about, I think, 3:30, but I filed it on September 26th, the last day. And as you know, I came to the courthouse at least 3 times before the 26th, knowing that that was a 3-day window
Mhm.
to get it filed, which I thought was kind of funny. They get 154 days, I get 3 days. But in any event, I did it. And I went down and filed my waiver on the 25th, I believe. They held that until I filed the complaint on the 26th. Thinking everything was fine, I get back home probably around 2 o'clock because my file wasn't working. And let me iterate that. I went down there to file my case by paper because of the 3-day window, and that was the 26th. They told me I could not file my case by paper and sent me down to the kiosk, which was broken, which made me have to go back home and file it. It had nothing to do with the password problem. I'm a substitute teacher in Macomb County. I know how to do passwords. And
Mhm.
so there was a problem with the submission, getting that temporary password. Excuse me, you're welcome. So once I got that temporary, whatever was happening with my file, which it was happening yesterday as well, I was trying to print out the actual time and date that clerk rejected my file. So once I finally got that temporary password to work, it was actually filed on September 26th at 1:51 p.m. according to the My File submission database. What else? The trial court in this matter did not consider the evidence under MCL 1.109 G5B in this instance and granted the defendant a summary judgment stating that time had been barred, or however they say it. The time had not been barred. They wanted to confuse the court to think it had been barred by saying I submitted it on October 4th, when reality is, when I found out that they said I did not put /S/ on September 26th, is why she rejected it. I drove back down to the courthouse on the 26th and talked to 3 supervisors, reiterating the importance of my date, that day, the 26th. Once I talked to all 3 supervisors, I have their business cards. I saw them yesterday because I was trying to get something to go print out from e-file and they couldn't do it. So I left and she finally showed me a little something. You gotta go home and do it. That was yesterday, e-file. And so once I told them, I said, hey, this is a time-sensitive case. I only have today now because I put my waiver in on the 25th. The dentist gave me the affidavit on the 25th. And then I filed it on the 26th. So I didn't have any time, no window. And I let them know that all day long as I was at the courthouse, letting them know.
So I'm a little confused, Ms. Howard. Are you saying you filed the lawsuit by a paper filing on the
I tried to,
26th?
but they wouldn't let me. I wanted them to stamp it and say, yes, she got it
What
in.
was the reason they gave you for
They,
not accepting
they
the
told me they
paper?
don't accept paper filings.
Okay,
You have to do it at the kiosk, which was right down in their little office in a corner.
okay.
And when I went down there to try to upload the copy I had on my flash drive, the kiosk wasn't working. And that was the 26th. They told me, well, you got to go home. I drove all the way back to Ferndale, typed it in, sent it, called the clerk. You got it in, Miss Howard. We see it. The next morning, it was all rejected. And so I'm like, okay. I went back down to the court. I said, hey, she rejected my, oh, you didn't do /S/. Huh? I didn't know. I'm not a
Alright.
lawyer, not trying to be one. So they allowed me to do the /S/. I'm not sure. Oh, if you look at Appendix B in the back, complaint 1, you'll see where I have the 26th. September 26, 2024. No /S/. I went back down there. I said, hey, what happened? They said, oh, you got to put /S/. So I did. When I did that, I filed it. They still worked. They still had a rejection there. And it was the weekend. They held it until the 4th. I kept going. I said, hey, it didn't go through yet. But I did get a notice from my file on my cell phone that it was in process. On 9/26, I lose my voice because of what's happening with my teeth, my mouth. They don't even know what's happening. I'm losing it now, swallowing this stuff because of the
Okay.
So I hope you can hear me.
Yes.
So anyway, once I told them, hey, what's going on? Don't worry, Miss Howard, your date is the 26th. Nobody can deny that. I said, well, it hasn't been filed. It says in process. That means it's filed. According to my file, anything submitted to my file, the submission is the date that you filed it, which is September 26th. And so that you see right there. I have my cases, according to Madden versus Roswood. Their motion for summary disposition, again, was to say, I didn't file it in time. And that was not correct because the defendant improperly invoked MCL 629-12D. The statute does not apply to tolling, discovery of injury, or notice of intent under MCL 600, you have it there, was cited in order to conflate and confuse and mislead the trial court. The plaintiff citing MCR 1.109G7 clearly states reversing the final order. There was no transmission failure, which is what the defendant wants you to believe, that I didn't get it through because I didn't know how to do a password. It was a password issue for the 25th, the 24th, and on the 26th at 12:30, I think you see it in there. They said everything's fine, which it was, and I filed everything on September 26th at 1:51 p.m. And I got that notice on my cell phone that said in process. They held it until the 4th. And then when I talked to the court, the supervisors, they said, yeah, they're still not releasing it because your case caption is wrong. You didn't put Wayne County or something on the case caption. And they held it until the next week, the 4th. And so when I retyped everything, trying to be neat, because they told me everything was fine, that my date was secure, I retyped the complaint. I retyped the complaint on 8x11 paper in relation to the actual complaint that is on scale. And I typed September 4th, 2026, because that was the day I was retyping everything, just out of neatness and respect of the court to kind of see what I was talking about. But the original submission date is September 26, 2024.
All right, I think we understand your argument quite well, Ms. Howard. Is there anything else you think you need to let us know?
I
'Cause I
think
think we have a
so.
good grasp of things here.
Okay, let me see, I think I had one more thing. Oh, concerning the notice of intent, they had 156 days to answer, which they totally disrespected the court in saying you have 56 days to answer, and didn't even try to answer my notice of intent until they found out I filed it on September 26th.
Okay, all right.
Yes, sir.
Thank you very much.
Thank you.
Appreciate your argument.
Thank you.
And counsel will have a chance to respond.
Good afternoon, Your Honors. Matthew Nichols, appearing on behalf of the defendant appellee, Dr. Smoller. May it please the court. It's always great to be here, especially on a gorgeous day like today.
Great to be inside here on a gorgeous day like.
Yeah, right.
Well, there's still plenty of runway left in the day. Believe it or not.
Out of the heat anyway.
Yeah, sorry to ruin your introduction.
It's okay. I'm going to take Judge Goodall's your cue of just cutting right to the chase. I know the court has read the briefs, are familiar with the facts. I don't think there are many facts in dispute in this case. So it's our position, of course, that the trial court judge got it right, finding that plaintiff's complaint was barred by the statute of limitations. There's really only two court rules that could have saved plaintiff from dismissal. The first is MCR 1.109 G5, which relates the filing the acceptance date back to the date it was filed.
Say that again. Which relates to?
G5. So
Yeah.
where a pleading is accepted,
Right.
and it has to be accepted, that acceptance date goes back to the date it was submitted. But that court rule specifically requires that the pleading be accepted. This court in an unpublished decision.
So if it's accepted after the statute of limitations expires, so long as it was filed before, but then it comes in under the wire, correct?
And this court examined this exact same rule in very similar circumstances in Jones versus Christ, Enderly, Hodgins, and Borsos. It's an unpublished opinion from 2020, docket number 348378. It was a legal malpractice case, still had a 2-year statute of limitations period. The plaintiff in that case had attempted to file the complaint. The complaint was not in compliance with 1.109D. I think it was undated, and there was the failure to list the prior actions involving the same parties and transactions. That
I think
pleading
there's
was
actually a published case that addresses this at this point, Goff versus Vitti. So.
okay. Point being, the court in Jones looked at the court rule language, said that the subsection G5 applies only where that pleading submitted is later accepted. Yep. For the other court rule is G7. So that's where, the inverse happens, where you attempted to file, it gets rejected. You have a mechanism to ask the trial court, treat that rejected filing or a subsequent filing as though it was filed on the submission date. That motion in this case was never filed by plaintiff. And even if she had, so the trial court judge never had a sufficient record to review. That argument was never made, wasn't made on appeal. But even if that were the case, sub rule under G7A3 requires that the transmission failure is not caused in whole or in part by any action or inaction of the filer. Here, the record is quite sufficient in showing that there were several defects in the filing causing the rejection that plaintiff had admitted, failure to comply with the signature requirements. So for those reasons, we think the court got it right. I know with statute of limitations, these cases are always coming up to the date where they are run. You don't see them where, you have weeks or months until your deadline meets. It's always coming up to that date. So
The claim of appeal is filed in our court, and let's say that there is some defect in that claim, we still treat it as being filed. And then we follow up with the appellant and say, here's the defect, fix it within 21 days. And then it relates back. There is not a similar rule here for what happened because she didn't type S/S and also maybe typed an incorrect case type.
Yes, Judge. I know this court is, has some degree of leniency with filings and rejections and having 21 days to cure those defects, which as an appellate
Because
practitioner,
we recognize that's a hard line, right?
right, but at the trial court level, it's a strict compliance issue, at least based on the court rules. I think if there were to be a change in these court rules, that would be up to the Supreme Court to revise them or make some sort of subsection allowing for defects to be cured within X number.
I think I dealt with this once before, but I think it was in the context of an appeal district court case to the circuit court. And my understanding was that the e-filing system was going to make that allowance, but you're telling me the court rules don't recognize it.
My understanding, Your Honor.
Okay.
Any other questions for counsel? No, I don't think so.
Thank you, Your Honors. I'll rest on my brief.
All right, thank you very much. You do, Ms. Howard, have an opportunity for rebuttal argument. This is not an invitation to re-argue your case or to bring up new issues, but only to respond to things that your opposing counsel just argued.
I hope I understand what you're saying. So he's arguing about the electronic filing, MCR 1.109.
Right.
5B, and it states time and effective electronic filing. A document submitted electronically is deemed filed with the court when the transmission to the electronic filing system is completed and the fees are paid. A transmission, I'm jumping down page 8. A transmission is completed when the transaction is recorded, regardless of the date a filing is accepted, regardless of the date a filing is accepted by the clerk of the court. The date of filing is the date submitted. And last but not least, FRCP 5D4, I'm asking the court to accept the document as the original submission from the date.
All right, very good. Thank you very much for
Thank you very much.
appearing.
Have
We
a good day.
appreciate your arguments and your case is submitted. We'll hope to have a decision to you quite soon. Thank you. All right, that brings us to item 21, docket number 371219, People of the State of Michigan versus Ryan James Williams.
Good morning, Your Honors, or afternoon. Tracy Gittleman from Mr. Williams. Two issues today in this criminal case. First issue, OV-19. Did the trial court properly score OV-19 where it is undisputed that my client, the offender, did not attempt to interfere with the administration of justice? It is undisputed that what happened here was that while he was in prison or in jail awaiting sentencing during the case, his wife did certain things to the victim. He would call and she would describe what she did and he would say, okay. He would, and
He
actually
was cheerleading her.
We kind
He
of
was
give her,
cheerleading her, wasn't he?
he was, I wouldn't say cheerleading her. I would say,
her at a girls.
I would say being in his position in prison, knowing that that's his lifeline to putting money in a account, a JPay account, to being able to speak to his kids, in the position he's in. He never said, don't do this, but he never said, do it. And the only thing that the trial court did rely on to score OV-19 was the very last call where she again said what she did, and he said, "I'm proud of you, great."
He did say,
cheerily.
"I love it."
He said, "I love it," and he said also,
Very good, okay. The hell with them, effing those, or F those bastards.
that is also undisputed. But
He felt he was woefully underpaid.
I'm sorry, Judge.
He felt he was woefully underpaid, didn't he?
You mean in his employment?
Yes.
I don't know that he felt necessarily woefully underpaid. I do note that from a mitigation standpoint, he did present to the trial court at sentencing a psychological report due to his trauma in the past and losing his father and things that have occurred in his life, that the point of buying things satisfied that feeling of loss, whatever loss he had. But nevertheless, with OV-19, it's a verb. The offender must do something, not another person. And his wife was not a co-defendant. So it's not like we have a co-defendant situation where we score the guidelines the same for one versus the other. That is not the situation here. It was improper to score OV-19 based on that because under the law, the offender must be the person that attempts to do it or does it. It's a verb. To attempt to do or do is meaning to do it, not to have someone else do something. And maybe you know, there's nothing in this OV-19 that says if someone told you they did something to interfere with the administration of justice, you must say stop. That is not required to score OV-19. That is not the law in Michigan. Nevertheless, it does not reduce the guidelines, so it would not require a resentence. And I would note that the PSIR right now is scored, it says OV-19 at 0, but it was scored at 10, so the points are 20. If that was reduced by 10, it would still be in the level 2 because it's 10 points. I, as a defense attorney, don't go about changing SIRs when they're favoring my client. So that is why that was not motioned up to be changed as far as correcting the actual number. Now, on to requesting a resentence. That is regarding the upward departure. There's no doubt that this was a crime that was over a period of time and involved lots of money.
6 years.
You got
Yes.
5 years for embezzling $565,000. That's excessive in your view?
I'm saying it is disproportionate and unreasonable, given the mitigating facts. Number one, his psychological impairment that was part of why he did what he did. The fact that he was remorseful, the fact that there is potential for
He's
rehabilitation.
remorseful when he's telling his wife, get after him.
I don't know that he ever told her.
Robocalls? We didn't even bring up the robocalls. My goodness.
He loved it.
Yeah.
I don't know. It is my argument that he was between a rock and a hard place. And
I understand your argument. I think it was what was made to the trial court, and the trial court rejected it.
I agree, Your Honor. I definitely agree. And I do also believe and contend that the trial court also looked at those calls that were done, and that was between the first sentence of the 10 years.
Correct.
And then these calls occurred, and then the judge was also reviewing that, and then he gave 5 years. I understand all that. But I would.
I mean, to tell you the truth, I'm trying to understand, was this just some kind of misguided, I'm just going to throw dirt on the victim and maybe the judge will reduce the sentence, or maybe the victim is so embarrassed by what will be so embarrassed by all of what is going on here that.
I can tell you that she was charged with harassment and she did plead guilty. So but that is the wife. That is not my client. Not my client.
No,
he was
I'm
in
glad to
prison the
hear it.
entire time. Not my client.
What did she get?
You know, I don't know. It might have just been probation. I don't know, because I don't know. I didn't write that one down and it's not in my memory banks. But another issue with regard to the disproportionate sentence is that the court, the trial court did review certain OVs that were scored 0,
Mhm.
that were supposed to be scored 0 pursuant to the legislature and how they have defined how we score offense variables. Yet the court was not happy with that.
Yeah, I think the court can certainly say, I believe that the guidelines are inadequate in this case for this reason, that this behavior or whatever happened here is not even considered, and maybe it should be. I don't see anything inappropriate about that.
There,
But I'm
those were
speaking
my
for
arguments.
myself. I don't, speaking.
I'm
for
here to answer any
everyone.
other questions. I know there's no other argument here, so.
All right, anything else?
No.
Ms. Gittleman?
No,
No,
thank
thank you.
you.
Thanks
Thank
for
you,
appearing.
judges.
Appreciate your arguments. Case is submitted. I'll call the last two items on our docket. Item 22, docket number 378314, In re A Mohica Howard Minor will be submitted on the briefs. Item 23, docket number 377942, In re I Gordon Minor will be submitted on the briefs. With that, we are concluded and we will stand adjourned.